to go back for a second to Justice Kagan's point about notice pleading, because as I understood it, this affidavit of merit is not discoverable, it's not evidentiary, it can't be admitted, it's sort of a black box thing. So why isn't that consistent still with a notice pleading kind of scenario?
I think this goes to something we call Schrodinger's law about the Delaware law. If it doesn't do anything evidentiary because it's totally secret, totally sealed, can't be used in the case, then it's got to be a pleading requirement, because what else is it supposed to be doing? It doesn't do anything.
So then where does the conflict come? I don't understand. I mean, it could be an additional thing. It doesn't have to be a conflict. If it is it seems to me that we only have a conflict from the standpoint of worrying about this extra thing that you have to require being in conflict with a notice pleading dynamic if the thing that is extra, this AOM, is requiring you to do something evidentiary in the course of the case, that it really is making a difference. It doesn't seem to me that from the Delaware law that this is even really evaluated by anybody. You just have to have it, and the court has to see that it exists, and then that's what is required to initiate your lawsuit. So how is that, maybe I'm not understanding, but how is that inconsistent with a notice pleading kind of dynamic?
The fundamental inconsistency is that you don't have to prove your case to have your case already proven to come into federal court and plead your case. You know,
so you're equating this AOM with proof that you have a case?
It's adding an extra piece of proof that you need to develop before you even get the aid of discovery, right? So you don't get the chance to depose anybody about what actually happened. So you have to develop this expert testimony based on whatever facts are available to you, which may be a very limited understanding of what actually happened. But I want to go to this idea of adding something extra. We don't think you could make someone attach a contract to a complaint or attach an insurance policy to a complaint to plead a case in federal court. That would just be adding something extra under state law, but it would be fundamentally inconsistent with Rules 8 and 9, which don't say you have to do something like that.
Wouldn't it also be inconsistent with Rule 12D, which says that if you're going to be judging a motion to dismiss, it has to be on the pleadings alone, so you would be closing your eyes to these other things, so that if you disobey the Delaware requirement of attaching an AOM, that really has no effect on the court's assessment of any kind of Rule 12 motion?
That is our fundamental submission about Rule 12 and why we think there is a Rule 12 conflict here.
But it seems to me that that kind of dovetails with Rules 8 and 9 in showing you what the universe is.
Yes, exactly, and showing the interconnected nature of these rules and how if you could just add, if a state could make you add something to a complaint, it would have all of these domino effects on, well, what would be the motion by which you would then test the sufficiency of that? Delaware had to create a special provision for testing the motion because you're not allowed to see the affidavit, so you have to make a motion for in-camera review because you don't even know if it's insufficient.